In general, the idea of naming and shaming is that it's a process by which a specific enterprise is identified and its offending actions publicised. And as we're all aware, the Hayne Royal Commission found that there were financial services entities that broke the law, but also that they were not properly held to account and that this was contrary to community expectations. The Royal Commission named and shamed the 4 major banks in Australia, but it also named and shamed the 2 major regulators of the financial sector, APRA and ASIC. The banks were found to have broken the law. Each of these regulatory bodies was found not to have met community expectations by not holding the banks to account. So what I'm trying to look at today, and what the paper, which will be available afterwards, looks at, is a research question. What are the regulatory implications of an industry-wide naming and shaming exercise where the regulated and the regulators both acted in a problematic fashion? And the paper analyses the Royal Commission case study, which contrasts the responses of ASIC and the ACCC to the change in law regarding unfair contract terms in small business. I'm going to suggest that naming and shaming of regulated entities has been restricted as a regulatory tool when the regulators themselves have been shamed. So, as I mentioned, naming and shaming is just a regulatory tool, and it belongs in the toolkit of regulatory tools promoted by responsive regulation. And this is what Ayres and Braithwaite described as effective regulation transacted through moral suasion. In the 2-step process for corporate naming and shaming, public disclosure of the offending company generates internal processes to identify personal responsibility for putting things right, and, to use the words of Voltaire, pour encourager les autres, which was something that the tricoteurs used to enjoy saying in front of the guillotine. Now, I'm really pleased that Dimity is the facilitator for today, because some work that Dimity did in 2011, so nearly a decade ago, highlights some issues associated with naming and shaming. One of the things that she said is that the tool may be less successful in regulatory environments where large populations of regulated entities and insufficient resources for visits, inspections, or other regulatory checks, and where detection of non-compliance is difficult. She pointed out that ASIC, as the conduct regulator of the sector, was failing to achieve the goals of responsive regulation to influence the regulated entities so that they may recognise, understand, internalise and operationalise the values of the regulatory regime in the operation of their business. The Royal Commission exposed at large the widespread misconduct in the financial services sector, and it was a thorough exercise of naming and shaming of the financial entities involved. But it also identified the regulators who failed to punish and deter that misconduct, both ASIC and APRA. So I'm looking specifically at a particular area. So the Australian Consumer Law, or the ACL, is Schedule 2 to the Competition and Consumer Act. And the ACL applies to general goods and services, and responsibility for its enforcement lies within ACCC and state fair trading bodies. However, financial services are governed by the Australian Securities and Investment Commission Act, or ASIC Act, and for that, not surprisingly, ASIC is the enforcement regulator. During the Royal Commission, the approach to enforcement by both regulators was compared through their respective responses to a provision introduced in 2015 to extend the law on unfair contract terms, or UCT, to small business contracts. The legislation amending both the ACL and the ASIC Act received assent on the 12th of November 2015, and it extended the unfair contract terms provisions in the ACL and to small businesses, and the ASIC Act to small businesses, with a transition period of 1 year. That is, it came into effect in November 2016. The fact that ASIC and the ACCC administered the same provisions in different areas enabled the Commission to compare the pair. The ACCC explained that in 2014 they'd started to prepare a new policy proposal, an NPP, to obtain funding towards engagement activities associated with unfair contract terms, and this was secured in the 2014-15 federal budget. This was in addition to the usual enforcement funding. The ACCC approached their process in 2 steps. For the year before the legislation entered into force, the ACCC focused on engagement activities and reviewed the contract terms of 25 businesses in 6 sectors. Once the legislation entered into force, the ACCC considered that industry had been given enough time and it would move swiftly to enforcement. It continued communication to industry to reinforce the message that the removal of unfair contract terms from standard form agreements would be a strategic enforcement priority, and it commenced over 20 investigations as soon as the legislation came into effect. It also started its positioning, so the ACCC has said that unfair contract terms should be a contravention of the Australian consumer law rather than simply being void if the ACCC or another regulatory body goes off to court. And within a year, JJ Richards was subject to a court order to void its unfair contract terms. Now, ASIC, before the Commission, laid out a completely different approach. ASIC did engage in engagement activities during that year between the law between date of assent and entering into force. It also discussed the ACCC's approach to review business contract terms of selected industries. It took a similar approach with 7 banks, including the Big 4 banks. But on the enforcement side, no investigations were undertaken, and a lack of funding was said to be the main limitation for enforcement capabilities. The hearings provided an opportunity for the Commissioner to contrast the approach of both regulators in terms of anticipation, actions, attitudes to engagement, and enforcement. The ACCC declared at the hearing that the review of target contract terms would have been conducted as a fairly fundamental part of our engagement strategy, regardless of funding. The ACCC had planned, obtained funding for, and executed a campaign prior to enforcement. ASIC had remained inactive. ASIC's account presented no acknowledgement of any need to improve its approach. The effect was that, in contrast to naming and shaming, in the same way that Macquarie Bank emerged as a model financial institution, the ACCC, in stark contrast to ASIC, became the model regulator. An integral part of the efforts to restore trust in the system have involved reforming ASIC's approach to prevent misconduct on behalf of consumers, as a reminder of the reform of culture that must take place at both sides of the regulatory contract, as Dimity also called for in 2011. ASIC's ASIC's response to the interim report contained an acknowledgement of responsibility and the commitment to change formulated as, "Why not litigate?" The phrase was meant to signal a change in ASIC's regulatory culture. The Commissioner gave it due consideration as indicating a change in that culture, and such a change had already been identified, again by Dimity a decade ago, as necessary if ASIC was to align more closely with responsive regulation. The final Hayne report concerned itself with the regulatory tools that a shamed regulator could use in the process of strengthening enforcement and restoring its credibility. Justin O'Brien notes that ASIC's response to the legislative changes to increment penalties present a chastened and newly empowered market conduct regulator with a potentially enhanced arsenal and a determination to use shaming as a deterrence tactic and strategic objective. This new enforcement strategy has seen ASIC taking Commonwealth Court, a move that signalled its intentions to restore its credibility as a regulator and correct former mistakes in court action that were exposed in the Royal Commission's hearings. Despite these professed changes, the reaction of the ACCC and ASIC to continuing issues in the law of unfair contract terms indicates that the cultural change advocated for ASIC may be happening at a slow pace. These differences between the ACCC and ASIC in their approach to unfair contract terms provisions question whether the shamed regulator has recovered its capacity to put things right. Reinforced as a model regulator, the ACCC has seen a reward in the form of the home loan price inquiry directed by the federal government in October 2019 that asked the ACCC to investigate matters in the financial services sector. Although interesting, the terms of reference forbids the ACCC to inquire into the conduct of the regulators. The position of the ACCC is markedly different to that of ASIC, where ASIC is intent on supporting government legislative reform agenda. O'Brien argues that only the ACCC has the capacity to relate to the normative framework offered by the Royal Commission to reconnect law and morality. This is larger work than ASIC can undertake before its credibility is restored. After the Royal Commission, ASIC's strategy to use naming and shaming may be constrained by at least two reasons. First, Hayne's warning that stronger enforcement should be sought by the conduct regulators has set a benchmark in terms of community expectation, and ASIC will be held to account for the application of its "why not litigate" approach. ASIC's updates on the Royal Commission recommendations and its efforts to increase investigations indicate that litigation is being taken as an indicator of ASIC's renewed enforcement strategy, in a position where litigation can be understood as a demonstration of leadership, but also as a response to the scrutiny of its actions. The instigation of court proceedings against Bank of Queensland, Bendigo and Adelaide Bank can be understood as a demonstration of both. However, ASIC's inputs into legislative changes in unfair contract terms show the limitation of this leadership. Arguably, ASIC's resort to naming and shaming is constrained by the role of the ACCC as the strong enforcer of the law. ASIC will continue to follow the lead of the model regulator in its application of the unfair contract terms law to the financial services sector, potentially to restore the credibility of the regulator itself. Thank you. I'd be very keen to take questions, and I'll hand back to Dimity.